Ladies and gentlemen, under the general topic weakness and effectiveness of the law, I would like to elaborate a bit on the specific rules that have been created for digital platform operators. Following approximately 4 years of their operation, I would like to take some track record and give a brief outlook on what is going to lie ahead. We will have a look at the development of things, have a look at the factual background, look at how the legislators in Europe and in Germany reacted to the challenges that they were facing. Then the main part will be basically taking stock of how the new instruments have evolved, how they have been implemented, before we will address a few questions that have been left open by these new laws. Now, the background, of course, is very familiar to you. You all know these large corporations, Google, Amazon, Facebook, Apple, Microsoft. So this is basically what we are talking about. Their initial letters have formed the acronym GAFAM, and that is what the legislators were facing when they had to address the issues that were enshrined in their market power, in their dominance in the beginning of the 2020s. In August 21, these 5 firms, big tech, amounted to almost 1/5 of the US Standard & Poor's 500 index. And in the beginning of 2022, their market capitalization was enormous. 4 out of 5 surpassed the $1 trillion threshold. And just to give you a slight comparison, at that time, the entire DAX 40, that is the German stock index for the 40 strongest corporations, amounted only to $1.9 trillion US. That's a bit more than Google alone. It's not only market capitalization, also the scalability of revenue was causing concern. I just like to give you a very brief example looking at the advertising business of Google. This is a table of a chart of the personalized advertisement revenue created by Google. You can see that is almost an exponential curve, and it amounts to almost 150 billion US dollar in 2020. And maybe the scary thing about it is that in 2021, only 1 year later, they already had a net profit of 76 billion euro. That is almost 50% of their revenue was profit. Now, how did the legislator react to the challenges that are, of course, brought about by such economic power? In Germany, the legislator embarked very soon on the special powers that come with these huge digital companies, with the tech companies. Already the 9th Amendment of the Act Against Restraints of Competition from 2017 had new provisions on market definition on platform markets. But it was only the 10th Amendment of this Act in 2021 that created a novel Section 19A that was addressing abusive conduct of undertakings of paramount significance for competition across markets. This provision is built in a 2-step proceeding. First of all, we need a decision declaring that an undertaking is of paramount significance for competition across markets. Only once this step is done, special powers are vested into the Federal Cartel Office to prohibit specific forms of conduct pursuant to Section 19A, paragraph 2. This 2-step proceeding was designed basically to address the problem of timeliness, of speed. The Facebook proceedings from 2016 had just eaten up way too much time to simply confirm that Facebook had a dominant position on a market. So the first step is there in order to anticipate for this very lengthy proceeding. The second special thing about this provision is it only gives rise to a supervision by one cartel authority, that is the Federal Cartel Office in Germany. There are no fines and no private enforcement that are brought about simply by the existence of the provision. Nevertheless, this provision is considered to be a clear-cut case of competition law. There is a theory of harm underlying that addresses the leveraging of market power across market borders, and that was already confirmed by the Federal Court of Justice in a judgment of early 2025. Within the European Union, things went a little bit slower and got a bit delayed because the initial proposal laid on the table by the European Commission in October 2020 for a new competition tool sort of went wrong, or you might say positively, it went into a more encompassing legislation package in December 2020 that was composed of the Data Act, the Data Governance Act, the Digital Services Act, and the Digital Markets Act. We are today only talking about the Digital Markets Act that is designed to control very powerful undertakings. The Digital Markets Act of course is termed an act in English language and by the way also in German language, but in fact it's only a regulation that was issued in 2022 and is applied since May 2nd of 2023. Different from the German provision in section 19a that we just saw before, the DMA is not considered to be competition law in the strict sense. Expressly, it leaves competition law unfettered, but it is considered to be a self-enforcing regulation. Like the German section 19a of the Act Against Restraints of Competition, the Digital Markets Act also works based on a two-step proceeding. Its first stage consists of the designation of so-called gatekeepers. And in a second stage, these gatekeepers are then subject to special duties on this market. Different from German law, the designation of gatekeepers under the DMA has nothing to do with market power in the strict sense. Rather, gatekeepers are designated if they provide a core platform service, which is an important gateway for business users to reach end users. And such a gateway is presumed with at least 45 million monthly active end users that are established or located within the European Union, and at least 10,000 yearly active business users that are also established within the European Union. On the second stage of the special duties that are established for such gatekeepers, the European regulation has no single source competition grounds like the German, like its German partner provision. Rather, it is a mixed bouquet of obligations that are not necessarily focused just on the protection of competition, as you can easily find out if you read Article 7. Now, if we compare both provisions directly, it is obvious that the German provision entered into force earlier. It has a head start of roughly 2 years, entering into force already in 2021, while the European provision followed suit only in May 2023. Both provisions, however, are joined in their regulatory technique. You first need the designation of gatekeepers or enterprises with paramount significance across markets in Germany. So the first act really consists of locking the targets. The first step, locking the targets, was addressed very quickly by the German cartel authority. Only a few months upon the entry into force of the new act, the Federal Cartel Office designated Alphabet, that is Google, to be of paramount significance across markets. That was even before New Year's Eve of 2022. Meta, Facebook followed suit in May 2022. Amazon followed in July 2022. Apple in April 2023. And the end of the journey was reached with Microsoft in September 2024. Only two of these three corporations appealed against this designation, but the Federal Court of Justice affirmed both designations in 2024 and 2025. As regards the European Union, the designation of the gatekeepers was tackled in a more generous, a more open way. We don't only see the big five, but in fact, the European Union has also encompassed Booking.com and ByteDance, that is TikTok, into their lineup of gatekeepers that are under special control. So with mission accomplished for stage one, the question is what happened on stage two? How far did the competition authorities dive into enforcing the provisions? Starting again with Germany, the first target was Alphabet, Google also for the special duties, and the first case that was addressed was the Google News Showcase case. Google News Showcase was a service offered by Google for publishing houses and online publishers. In Germany, they were given a chance to publish their high-value content at Google News and Google Discover in form of so-called story panels. Now, unfortunately, Google's own content was typically preferenced over the search results of Google News Showcase, and this discrimination of publishing houses was the object of the proceedings, and in fact, intervention of the Federal Cartel Office led to an improvement of the situation of publishing houses when they were using the Google News Showcase format. Still addressing Google, there were other proceedings relating to the data processing rules of Google. And in October 2023, there was an intervention of the Federal Cartel Office that led to a better control of personal data for Google users as opposed to the practice before. Google was not only the first target, but also the prior target of the Federal Cartel Office in the early stages of enforcement. The third service that Google offered was the Google Maps service. Google Maps is, as you may know, widely used by car makers and included in their satellite navigation system. It is included in the automotive infotainment system. And of course, there is a service agreement, a license agreement between Google and the car makers. There were some infringements found in these license conditions, and these infringements were brought to a stop by commitments that were taken upon by Google to stop these restrictions of competition. Now, changing the targets, turning to Amazon. With Amazon, it was mostly price control that attracted the attention of the German competition watchdog. We have one proceeding that relates to price control. It's about obstruction of dealers on Amazon Marketplace. Their pricing was claimed to be obstructed by Amazon's own pricing algorithms that tended to undercut the independent dealers' prices on Amazon. A second case relates to what is called brand gating. Independent dealers, again on Amazon Marketplace, were obstructed from selling branded products because Amazon had made agreements with trademarked goods in order to protect these trademarked goods from competition on Amazon. Both proceedings are still ongoing, so we don't know about the outcome. The same is true for the proceedings against Apple. Apple has an app tracking transparency framework, and this app tracking transparency framework tends to prefer Apple's own information, its own data record, and it tends to prefer Apple itself with respect of own advertising as opposed to external platforms. Finally, we have Facebook. Facebook was the first and most prominent target of the Federal Cartel Office in the Pay or OK proceedings. But turning to Section 19A, actually the first case was the Oculus case. Oculus is a producer of virtual reality spectacles. And Facebook first had purchased the entire company, and then they had basically turned to allowing users of Oculus VR specs only with a Facebook account. Now, the Federal Cartel Office intervened in this situation, and in fact, as a first result, Meta has to provide for other forms of use of these VR specs. However, the proceedings are still ongoing. There's a continued examination of other possibilities of using Oculus VR specs offered by Facebook. And there's also a scrutiny of the combination of data that are gained by Facebook by the use of these VR specs. So that was it about the German law. Now, how about the European law? As the European provisions entered into force only 2 years later, it comes without a surprise that the first serious results only kicked in 2024. In 2024, we saw 6 non-compliance investigations of the European Commission. They regarded 3 gatekeepers, Alphabet, Apple, and Meta. And we got 2 preliminary findings, but they were only preliminary. So what was it? The first preliminary finding related to Facebook. And for Facebook, the problem was that following the German proceedings, the European Commission had gone after the binary choice that Facebook had left its users either to consent with the use of data or to pay for advertisement-free use of their services. These proceedings ended in, or had an interim end in the preliminary findings of July 2024. Apple failed to enable its end users to easily change the default settings on their operating system. And this also concerned the web browser choice that was given on the screen. Proceedings were opened and led to a change of Apple's setup in August 2024. And this was also basically the blueprint for the entire sector, for the entire industry, because similar decisions were taken for Alphabet on Google Chrome and for Pixel, and also taken for the choice of Microsoft Edge on Windows systems. In 2025, we saw the first news that basically hit the public domain, and that was, of course, the fines that were handed down by the European Commission. First of all, fines for steering terms that Apple had with respect to restrictions that were imposed on app developers. So they were basically induced to make use of Apple's App Store instead of making use of alternative ways of distributing their own apps. These steering terms were fined with 500 million euro in April 25, and on the same day we saw the final decision of the European Commission in Meta's pay or consent model. In this case it was a 200 million euro fine that was handed down. Both fines at the time were considered to be rather on the low side than on the high side, but probably that was correct, given that it was the first serious enforcement actions taken by the European Commission. So that was basically it with what has happened so far. Now let's turn to the questions that have been left open by the European and German legislature. Now the first question, of course, relates to the relationship between European Union action and Member States action. This is particularly open question as the Digital Market Act addresses or aims at a full harmonization of rules. But on the other hand, it leaves competition law without prejudice, as it's laid down in Article 1, paragraph 6. What does that mean? Now, in fact, it means that everything that member states regulate under the guise of competition law remains unfettered, remains in action, and does not conflict with European provisions. So this is basically the shield under which also Section 19A of the German Act Against Restraints of Competition is sailing in this case. But what does it really mean, this coexistence with instruments like Section 19A of the German Act Against Restraints of Competition? There are advantages, clear advantages. First of all, the member states' legal systems may offer sort of sandboxes to experiment with new kinds of regulations. It may be much more easier and more adaptable to fact patterns, to real-world fact patterns than the European legal system. It is also possible to share the burden of enforcing the provisions between the European Commission and national authorities. When we talk about sharing of burdens, it's also possible to allocate the task in correspondence with specific expertise or economic effects on national markets. And finally, we may also find a different regulatory technique advantageous in either one situation or another. Now, what are the advantages of such a split system are at the same time, of course, disadvantages, right? There is no more one-stop shop for the undertakings. They also have not only to bother with the control system within the European Union and the United Kingdom, for example, but also even within the European Union with the German system, the French system, the Spanish system, and whatnot. Also, this splitting of system also risks to lose homogeneity of the legal system as a whole within the European Union. For the moment, this coexistence seems to be quite well balanced, and the disadvantages, the cons that I just mentioned, seem to be well covered. Currently, it seems as if the European Commission made the best out of Germany's advantage with respect to time and practical experience. There's also close cooperation between the Federal Cartel Office in its probes of the Amazon's pricing practices and the European Commission's own analysis of the company's compliance. So far, we do not see any practical negative effect of this coexistence. I just mentioned the difference in the regulatory technique, and in fact this difference in regulatory technique may come in handy for specific purposes. We saw that the Digital Markets Act offers immediate fines, such as were just handed out against Apple, against Meta. This is different from the German system, where you first have to have the prohibition of the Federal Cartel Office, and only upon an infringement of the prohibition you get fines or you get private enforcement. These fines may be more handy for specific types of infringements, and they match, of course, the very clear-cut and very precise infringements that are laid down in the Digital Markets Act. On the other hand, Section 19A of the Act Against Restraints of Competition offers very open textured fact patterns that allow for a much more flexible and comprehensive cover of new business practices that may give rise to concern. Yet on the other hand, they are softer, they are more protective, they only give rise to a Federal Cartel Office's power to speak out a prohibition, but no direct fines. The other question, or maybe the central question that is left open, relates to getting back to the central topic of this volume, the effectiveness of the provisions. Is the system that we have developed fast enough? Is it strong enough to cope with the challenges? Now one might say, obviously it cannot be, because the Digital Markets Act, even 2 years after or 3 years after its creation, is already under revision. In fact, the European Commission has started a public consultation in July 2025, and the background of this public consultation may be seen in a perceived gap relating to the cloud services and generative AI sectors. They are not covered at all by the Digital Markets Act, and hence they should be taken into consideration. But it may be argued that this is rather a stronghold of the European system that is alert to recent developments. This is not really a weakness. Weakness might be indicated because it's not strong enough, and in fact all the cases I explained to you, except maybe from the Facebook cases, they just look rather specific and just peripheral, but not really attaching the core of the problem. Well, at least the political opposition against the Digital Markets Act should indicate that it is perceived of as an effective safety fence against specific forms of conduct in the digital economy. Of course, we still have to weather the storm that's lying ahead in the tariff talks, in the trade talks. It is a known fact that has become part of the tariff talks with the United States that the Digital Markets Act control should be reduced. A draft proposal has been circulated by the US Trade Representative's Office. And maybe there has been some sort of compromise that has not yet been published, consisting of some sort of cooperation of US representatives within a committee, a joint commission for the application of the DMA. At least Commissioner Ribera has rejected that the European control of the digital attack firms should be reduced or abolished, done away with altogether. So we will see what the future will bring in this respect. So to answer the question about the effectiveness very briefly, is the system fast enough, strong enough? Well, I'm afraid even competition law, even the rules on the large tech firms will not offer a simple solution that does away with all problems. It is a long and winding road, and we have to do all the footwork it takes to get up the hills and maybe sometimes down the declines in a controlled manner. And I'd like to finish the fundamental problem lying behind it with a statement of one of my own academic teachers, Ernst Wolfgang Böckenförde. I switched to German for a very brief phrase. Der freiheitliche, säkularisierte Staat lebt von Voraussetzungen, die er selbst nicht garantieren kann. The liberal and secularized state is based on conditions it is unable to warrant. And this is probably something that we also have to have in mind when we talk about weaknesses and effectiveness. Every provision that's fully effective may be effective with regard to its primary goal, but maybe also destroy the rule of law that is built upon. Thank you very much for your attention and your curiosity. Goodbye.